Hello, this is Erica Norton, and I am the founder of Perfect Legal Video. I'm very excited to have with us today Attorney Nicole Reeves Lavallee. She and her team are amazing at what they do. She owns a family and real estate law firm in the Worcester area, and we are very lucky to have her with us every week to discuss different topics that can save you a lot of frustration and money. Today, we're going to be talking about evidentiary hearings. And I want to thank you again for coming on the show today, Nicole. Welcome.
Thanks for having me.
You're welcome. So, evidentiary hearings, it sounds like evidence. What does that have to do with family law? It makes me think of CSI when you say that.
It's another version of a mini trial, if you will. So it's a very limited issue that the judge is going to hear, and they're going to hear testimony with people on the stand. So essentially, like I said, it's a trial congested to one little itsy bitsy thing, not a full blown trial on the underlying complaint, but maybe something specific like, does somebody need to vacate their home? Are they in contempt? Just a narrow issue on these one particular thing that we're going to discuss, and the judge wants to hear actual evidence, which means actual exhibits as well.
Wow, it sounds like they know that a lot of times these divorces or whatever, a lot of the family matters that go to court can take a year, 2 years to actually solve and finish. And so there are certain issues that need to be taken care of right away. So what are some of the evidentiary hearings that you actually handle?
Well, the biggest one and the most popular one is going to be a contempt. So you may have an underlying complaint for divorce or complaint for modification, and sometimes you want to consolidate them together because they're intertwined. Um, because, Judge, I really don't want to address this one particular issue. We'll just throw it into the mix of the divorce. We can address it at the final hearing. And sometimes you're like, we really need a decision on this one particular thing. Maybe it's, hey, somebody's in contempt of court regarding a legal custody issue, and we need to nip this in the bud because we don't want it to continue and we don't want to set a precedent. So, again, depending on what it is, you're going to make the determination as the person moving to say, hey, I want an evidentiary or I want to consolidate. Now, the good thing, if you will, is the defendant is the only one that gets to mandatorily require evidentiary. If they say it, it's automatic. They will get it on the contempt because theoretically they could be subject to sanctions and attorney's fees. So they have that automatic right, their due process rights to have an evidentiary hearing. So sometimes it works for you, sometimes it doesn't, again, depending on whether you're a plaintiff or the defendant. That's the most common though.
Is custody ever part of that or visitation rights?
Not unless it's, again, on a contempt. So you already have a court order and we're going back on that particular thing. So same thing with, child support. There's a child support order. You're supposed to pay $100 a week. You haven't paid it. 3 months go by. I'm going to file a contempt while the divorce is pending.
So it could be anything that they're in contempt for. And a lot of times the contempt is for rules that are already in place in your agreements. And I guess it's tricky because you don't have all of that completely figured out, but you do have the temporary orders. Is that right?
Correct. In order for any contempt to even be brought, you have to have an underlining court order, whether that be a temporary order or a judgment, but you have to have a court order in order to enforce it because that's exactly what you're saying. You're in violation of that court order. So a lot of times you will have it during the pendency of a case. And when you're talking about a divorce and we're litigating everything and it's a 2-year divorce, a contempt is generally going to be heard in 30 days. Will you get your evidentiary hearing in those 30 days? Depends on the judge and depends on the circumstances of what your evidentiary topic is.
Does the contempt and the evidentiary always go hand in hand?
No, it's only going to be based off of the request of a party. So any person is allowed to request an evidentiary hearing and the judge must grant it in a complaint for contempt. In certain things like a motion to vacate the marital home in a divorce, that again needs to have your due process right. So you will get an evidentiary hearing sooner rather than at the time of trial, because you're asking the judge to make a motion to allow this person to vacate the home before the divorce is final. So in particular circumstances like that, you're going to want that evidentiary hearing closer to the beginning of your case than the end of it.
Right, because some of the other things we talk about is don't leave the home if you're going through a divorce until you have permission. And this would be one way to get permission.
Correct.
So if we're going in order here, number one, you have to have your temporary orders in place. And there's probably some sort of hearing for that. Is that correct?
That is correct.
Okay. And then the second thing is that you have this list, but in order for you to bring up contempt and try to get that settled, the person has to really be violating this thing for a while. I know that you have actually told us, I mean, you got to keep track of things. Like sometimes you'll say they have to do the thing 3 times before you can really say that it's contempt. What are the rules? I'll just have you repeat those because I'm just kind of going off like a faint memory because we haven't talked about contempt in a little while, although it is one of our favorite topics.
And I would generally agree with that statement. It is generally 3 to 4 times. Again, depending on what it is. I'm dropping the child off late a half hour every time because I wanted the extra half hour and you wouldn't give it to me. After the third, fourth time, absolutely. I'm not paying child support. Again, after the third or fourth time, file. Because one, it's a cost effectiveness, and as well as, you're running into court over what? The judge wants to see that there's a pattern, that there's some real reason. Obviously, if we're talking about, hey, they decided to, put Sally in counseling, and I'm absolutely opposed to that, and we have joint legal custody, well, then wait a minute. Obviously, we can't wait to 2 or 3 sessions. We do it now. So again, depends on what the circumstances are, but the general rule is multiple times being 3 or 4 to show a pattern. But again, certain things warrant an immediate response.
So, how do you show the pattern? Is it that you contact your attorney each time it happens, or they tell the person each time it happens that, hey, you weren't supposed to do that? I mean, because otherwise it's just a he said, she said thing. If you don't have it somehow official, how, I mean, and maybe that's not even a problem, but maybe you should clarify this because I think a lot of people out there are just going to say, "Oh, well, he did it 10 times already over the last 2 years." Okay, well, says who? And is there documentation? Like who needs the documentation and how do you track that?
You don't need documentation. Would I encourage you to have documentation? Absolutely. I mean, obviously, it's hard to prove a negative. How do you prove that they didn't pay child support? Okay, well, it's in the bank account and I didn't get it. Obviously, if you're going through DOR, that's something. Oh, he paid me cash. Well, okay, again, gray area that you have those issues. So it really kind of depends on the circumstances. But, you showed up 30 minutes late for your parenting time again. You need to stop this. Send an email, send a text. Now you've got a record of it. Why are you, telling our child that she can go skydiving? Great. That's an inappropriate thing. You've got to document that stuff. So anytime you can document, and obviously the easiest way to document is to directly communicate with that person and say, hey, you're not doing X, Y, and Z. The court order says this, and you're doing that. And that's really what it boils down to, is being able to show the judge that I tried to have a conversation. I tried to work it out. The other person was being unreasonable. After multiple times of going through this is where we're at.
And how often do you see this? I mean, this is what you do for a living, and I tell people all the time. And in fact, I just referred someone to you today. That's it's just when you need an expert, there are important things that happen in your life. And if this isn't your line of expertise, you need an expert. So I guess like the question I have for you is, you need like when do you call in an expert? I mean, like I am always so thankful to have you because when I have a question, I can ask you and you can give some clarity, you can give a strategy, you can say, you know what, that's a waste of your time. I mean, which is almost as important as anything else that you tell me. So, quite honestly, you don't want to waste time and money on something just because you're mad that day. But like, I guess give us an example of, yeah, it's easy to prove. It's easy to prove the money stuff because you can tell, when somebody gets that in there. It's probably not so easy to prove when somebody says, "Oh, well, you said something bad about me to Susie, and so now Susie doesn't like me," or whatever it is. Um, there are things that are easy to prove and things that are hard to prove. So I guess what are some of the ways that you can make sure that there's proof so that you don't sound like you're just going up there with a he said, she said situation, which I feel like it happens all the time in these courts.
Well, I think, the old adage is if you can show something like we're supposed to have a pickup and exchange at 3 p.m. and we're meeting at the mobile station. Go into the gas station at 3:20 and go, look, still haven't gotten any money. Have a receipt here showing that he's still here. He's still not here. So you have things that you can show that I was with somebody, or that I did this at this time. Why would I be sitting here waiting if I didn't have to? So those are good things. Obviously, if you have a family member or a partner or a coworker, somebody that's listening in while he's saying something to you and Sally's in the background, great. You know, do you get those all the times? No, but obviously you can do the best you can, which is why I always say, if nothing else, you send them a document, an email, a text, or something saying that was inappropriate. Normal people are going to say, are you out of your mind? That never happened, if in fact that never happened. The reality is the people that say something are like, well, no, that's not exactly what was said, or that's not true, or they just ignore it. Those are telling to the judge because, again, normal reaction is, are you out of your mind, Erica? I never said any such thing. So it really depends on the circumstances and what specifically you're looking at. Now, when you talk to your attorney, again, kind of use your judgment. If this is the first time, maybe you get insight and go, how do I handle this? How do I prove my point? And obviously, the attorney can give you tidbits based on their experience and based on the circumstances. But do you need to tell them the second time? Probably not if it's the exact same thing. Now, maybe if it escalated, you want to tell the attorney. But again, you want to wait to that third or fourth time before you go, hey, we really need to do something about this to move forward.
So you don't necessarily need to tell your attorney right away, just as long as you have a written account of it. Number one, you always say to everyone, write things down, have a calendar, make sure that you know what's going on. And the second thing is to really, if you can send a message, like you can even send a message saying, hey, we're waiting for you. Is everything okay? Because it's 3:20 and I thought you were going to be here at 3. I mean, honestly, I've had so few verbal conversations with my ex in years because you have said like get stuff in writing and that is like really important. Um and I hope that there's a day where that doesn't have to happen, but I mean, unfortunately, uh, if you get stuff in writing, then you're protecting yourself later on. So, what are some of the biggest mistakes that you see people making, people that don't watch this interview on a regular basis? Because there's one thing that comes to mind that we just mentioned, but I'm sure there's a few mistakes.
I think the biggest mistake is reacting. It's that reaction. If they're doing something wrong and you start getting out of control, I can't believe you. You're a piece of crap, blah, 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 blah. What are you doing? You're putting yourself in the exact same situation of what your ex is doing, especially when you're going, there's going to be that no disparaging language, and you just did it in front of the child. So you're setting yourself up by reacting. Don't react, document. Make sure you're thinking about yourself and protecting yourself and your child, because that's first and foremost. That's what you need to do. You always need to have a level of professionalism, and that's the best way I can say it. Like, if you did that at your job, you'd be fired. So you have to try to keep whoever that person is that eggs you on, and think of them as a professional and just go, no, I'm better than that. And you really are. The problem is they know how to push your buttons. They do, and they do it so well. And so that's what's the triggering thing is always that reaction is the worst thing to do. The best thing is always to take that step back, treat it as a profession, treat it as, oh my God, if I did this in front of my boss, I'd be fired. And we're going to let him get fired. We're just going to let him do it in front of the judge, and the judge may very well take away custody or, hurt him in some way that we don't have right now.
I mean, that makes a lot of sense. I mean, you've always said that whenever you email or text somebody, just know that everybody in the court will have access to that, including the judge, and most likely they'll be reading what you're saying. So whether or not you have a good point in the literature, you're going to want to make sure that you do sound professional. And yeah, occasionally you can, I guess, spout off, but it's really not going to behoove you in the long run if that's your general stance. It's it's just going to make you look bad.
And again, if we go back to evidentiary hearings versus just a regular hearing, I'm getting up there and I'm saying, hey, my client would testify that X, Y, and Z had happened, right? Versus the client actually getting on the stand, and I'm asking her questions, and I'm saying, so Erica, tell me about this day. Guess what? You get to be emotional. You get to show exactly how you feel. You get to say exactly what happened. That goes a hell of a lot longer and faster than this scenario of me making that allegation. So that's why evidentiary hearings are important, because the judge really does see what is happening. The judge also sees the demeanor between both parties. Now, obviously, sometimes we're going, my client is going to be a horrible witness. But that's why you have the documentation and you have yourself. So again, you and your attorney are going to really come up with scenarios to say, is this worth it to do an evidentiary hearing? Does it make sense for what my future is going to look like in regards to a decision that's going to be made? Is it going to have an impact? Is it going to be a financial impact? Is it going to hurt my livelihood? All of those things are going to come into play that makes the determination as to whether or not evidentiary is the way to go, or just make an argument with counsel.
I mean, this is really great advice. And the best advice that I have is to absolutely hire Nicole if you have a situation like this, because you don't want to go this alone. It is a slippery slope. You can get yourself in trouble very easily. I'm sure Nicole sees that every day. In fact, when we're in court together, we've seen people just get themselves in trouble in there without an attorney, making themselves look like idiots because they get emotional. It's hard. You're human, you know? So find somebody like Nicole, who is really great at being professional all the time and, telling you like it is. You got great strategies. There's a few options, and what happens if you take each one of the options? And that's really what you need. You need someone that is intelligent in the ways of family court. And for me and everybody I know that has used Nicole, she's just extraordinary at what she does.
Thank you.
You are welcome. Is there anything else that we've missed about evidentiary hearings today? Because I know we've gone on a few tangents, but it's such a wide topic and there's several pieces to it that you need to consider before you consider the actual hearing. So I'm glad that you were able to take us through all that, but I don't want to miss anything.
I think there's two really, small points there. One is, an evidentiary hearing most likely will not be the day that you go into court. So if you're going into court on contempt, the judge is probably going to mark it up for a different day because they probably have a courtroom packed of people and they won't have time. Sometimes they can go, I can do this as an evidentiary in the afternoon, assuming it's only the parties and maybe it's just a financial issue, right? That's easy versus, hey, I'm going to hear testimony about 5 instances of abuse. Well, that makes it a little bit harder. So, depending on how in depth it is, chances are you're going to have a different hearing date than the first date you go in on. The other issue is, again, it's a mini trial. So, the attorney's going to have to prepare you. You're going to need to know how to answer questions. You're going to need to know how to listen and comprehend those questions to be answered. And then obviously, lastly, is you're going to spend more time with your attorney, which means it's going to cost you more money. So you just need to be cognizant of all of those things when a decision is made for an evidentiary hearing versus a non-evidentiary.
Well, that is great to know. I want to thank you so much for coming on today. We appreciate you and all of the time and the effort you put into educating us on really important topics in family and real estate law.
Thank you.
You are welcome. And we'll see everyone next week. Thank you so much for joining us. Have a great day.